Please, Your Ladyship, my Lords, before coming back to Bonington, it occurred to me that in making the submission I did yesterday, that one can see that the Bermudian Court of Appeal was not following Fairchild because of the citation to Lord Hoffman in Gregg and Scott. I haven't given you the reference as to why we make that submission, and I hope it might assist if I simply give it to you. It arises, the relevant part of the judgment is at page 159, red, I hope 66, black. And as the court, as the board will recall, it's the end of paragraph 40. There were two dissenting opinions and two statements by Lord Hoffman. The reference to the statements by Lord Hoffman is at page 391, red, within the appellant's, I beg your pardon, respondent's skeleton argument. It's to be found at 393, red, I hope 300, black. It's not a very good copy, and so it may assist if I simply indicate that the paragraph numbers were 80 and 84.5 within Lord Hoffman's opinion.
This is in his opinion where?
I beg your pardon, my Lord?
In which case?
This is in Gregg and Scott. This is in Gregg and Scott, yes. Yes. So those are the passages. They're referring to Gregg and Scott. They're referring to two passages of Lord Hoffman. We respectfully submit that one is entitled to infer that they're the passages to which their attention has been invited within, I'm sorry, back to inferences, within the respondent's skeleton argument, but it seems quite likely. And if one then looks to see what Lord Hoffman was saying, one can, paragraph 84 is the critical one. 80 is in bundle 7 4 paper page, as it were, 2232. I hope it is electronic page 3313, my lady, for 80.
Electronic bundle isn't working. Ah. That's not your fault.
Well, yes, there is actually said for it. Lady, I think I can I read a very
Mine isn't working sometimes.
Did you say 84?
Yeah, 84, my lord, yes.
Sometimes overnight they go to sleep and you have to reopen them. But unfortunately we can't reopen them because they're on case lines. Which is what the source of all the problems is.
Yes. Is it a paragraph that begins academic writers?
Yes, my lord, it is.
Yes.
Right.
And
I'm going to have to go to paper now. Isn't that terrible after all this?
It's volume 2, tab 20.
Thank you so much.
Well, yes, it's either volume 2 or volume. I was using the core
It's in
volume,
volume
which is
7,
volume
actually,
7. Tab 4. I'm sorry to be tiresome, but I've tried to stick to the core bundle while I can.
No, that is convenient. Yes.
So bundle 7, tab 4, page 2231 is para 80, but the critical one we respectfully submit is the end of para 84, because the argument being run in Gregg and Scott was, of course, that the Fairchild exception should be applied in those circumstances. And what Lord Hoffman has to say at the very end of paragraph 4, about 6 lines, picking it up about 6 lines from the end, in effect, the appellant submits that the exceptional rule in Fairchild's case should be generalised and damages awarded in all cases in which the defendant may have caused an injury and has increased the likelihood of the injury being suffered. In the present case, it is alleged Dr. Scott may have caused a reduction in Mr. Gregg's expectation of life and that he increased the likelihood that his life would be shortened by his disease. It should first be noted that adopting such a rule would involve abandoning a good deal of authority. The rule which the House is asked to adopt is the very rule which is rejected in Wiltshire, was expressly approved by the House in Fairchild. Hotson's case, too, would have to be overruled. Furthermore, the House would be dismantling all the qualifications and restrictions which it so recently hedged the Fairchild exception. Yeah. There seems to me to be no new arguments or change of circumstances which could justify such a radical departure from the precedent. But with great respect, with those words ringing in their ears, it would be very surprising if the Bermudian Court of Appeal, and actually referred to within their judgment, if the Bermudian Court of Appeal were to adopt some modification of the Fairchild exception to the circumstances of this particular case. That's why I made the submission. I'm sorry I didn't deal with it yesterday in the appropriate order, but I'm afraid I, in the excitement of the moment, forgot. May I move back to Bonington? And may I start by summarising the submissions we make in relation to Bonington. I think I did this yesterday, but I may be able to set it out in slightly greater clarity. We submit that when scientific uncertainty or medical uncertainty precludes answering the but-for question, either positively or negatively, then Bonington is authority for the proposition that the court should then consider whether the claimant has proved enough for the court to infer that the defendant has caused at least a part of the damage. If so, in other words, the court is prepared to...
Could you write this down on a piece of paper?
Yes, my lord, of course we can. May I just run to the end, and we will then hand in a piece of paper. If so, then the court will normally apportion. There is no need to apportion, though, we submit, or the court will not apportion in two circumstances. One, if the apportionment point is not raised, and two, if it is scientifically impossible to separate the innocent from the guilty part causation. We'll come back to that, because one of the questions that my Lord Hodge raised at the end of yesterday was whether I would deal with the Stapleton article. I propose to do so, if I may say so, when I get to Bailey, but we respectfully submit, and I just put it in at this point, that there is authority for that proposition within the Stapleton discussion, that that's how Bonington should be approached. On top of that, we respectfully agree with my learned friend that whilst the starting point is whether it is appropriate to draw those inferences under Bonington, there are then further qualifications that need to be met. We don't agree about the qualifications, but we agree there are further qualifications that need to be met before it is appropriate to draw the inference. And the short point we make is this, that if we're right so far as the starting point, which is whether it is reasonable to make the inference, and then the qualifications, this is by no means a case in which it may be said that if you have increased the risk under Bonington, you pick up the bill, which I think is rather what was being suggested. We submit that there are quite clearly layers of judicial consideration between, as it were, the end of the straight but-for calculation and the conclusion that there shall be partial liability or complete liability in the appropriate case. May I pass on then to the cases following Bonington? This is within our written case, paragraph 64 to 67. I don't take the board to those paragraphs, but I would respectfully remind you of the decision of Lord Simmons in Nicholson and Atlas Steel Foundry Engineering Company Limited, which we submit. He was, of course, on the woolsack in Bonington, but it is clear that he affirms the decision that is arrived at in Bonington within Nicholson and Atlas Steel Foundry Engineering Limited. And we respectfully submit that the approach adopted within Nicholson affirms the approach which we have indicated submitted arises from Bonington. We do not submit, it follows of course, that simply increasing the general risk of damage is adequate. It follows of course that we don't submit that either Wilshire or Tahir is wrongly decided.
Wilshire, I think you mean. I heard you say Wilson, but I think...
Wilshire, I said, well, I'm so sorry, but
I think you meant Wilshire,
If I didn't, I meant to say Wilshire.
Yes.
I meant to say neither Wilshire nor Tahir is wrongly decided, because those are simply increase in risk cases. And as such, unless they can be put into what your ladyship described as the Fairchild box, it becomes very difficult to see how the claimant could succeed. May we pass on then to the effect of Bonington? And the first question that is posed, perhaps, is you talk of a partial cause of damage. What damage? And this echoes, we respectfully submit, questions that were being asked by, I think, Lord Hughes yesterday, or Lord Hodge. Was it, what about the sepsis, as it were? Is a contribution to the sepsis of itself sufficient? We respectfully submit that there's a valuable and helpful discussion of that within one of the cases upon which my learned friends lay such stress, which is the decision of Lady Justice Smith in the Court of Appeal in the Atomic Veterans litigation. That is paper, volume 4, tab 32, pages 1198-99. This is the relevant part. And I hope electronic 2222, oh, it's 4 twos, to 2223.
Paragraph.
Look, ladyship would give me
150 is the bottom of 1198. It's around there.
Yes, it's the. I picked up 1198, paragraph 149, I think. Yeah. We accept the submissions. I don't know, I'm afraid. I hope that's the first of the electronic pages. But
Yes, it is.
Good.
Yes. That's why I was asking for the paragraph number.
Yes.
Confirm. Now you've cracked it.
Yes, good. We accept the submissions of the MOD first. Unless there were to be an extension of the first child exception, the claimants will have to show the but-for causation, see Wilshire. Second, we accept that at least so far as cancers are concerned, the claimants cannot rely on proving that the radiation exposure has made a material contribution to the disease, as in Bailey and Bonington castings. This principle applies only where the disease or condition is divisible, so that an increased dose of the harmful agent worsens the disease. As is well known in Bonington, the claim succeeded because the tortious exposure to silica dust materially aggravated to an unknown degree the pneumoconiosis which the claimant might well have developed in any event as a result of the non-tortious exposure to the same type of dust. The tort did not increase the risk of harm, it increased the actual harm. Similarly, in Bailey, the tort, a failure of medical care, increased the claimant's physical weakness. She would have been quite weak in any event as a result of the condition she developed naturally. No one could say how great a contribution each had made to the overall weakness, save that each was material. It was the overall weakness which led to the claimant's failure to protect her airway when she vomited. Was the result she inhaled her vomit and suffered a cardiac arrest and brain damage. In those cases, the pneumoconiosis of the weakness were divisible conditions. Cancer is an indivisible condition. One either gets it or one does not. The condition is not worse because one has been exposed to a greater or smaller degree of the causative agent. Now, looking at, and Lady Justice Smith does not suggest that Bailey, on its facts, was wrongly decided. She doesn't also go into the academic criticisms of Lord Justice Waller, to which I'll come, the end of Lord Justice Waller's passage, to which I'll come later. But what we respectfully submit is important about that passage is that Lady Justice Smith, in the Bailey case, is looking not at the aspiration of vomit and the brain damage, but at the weakness. So it is the first part of the injury that she's looking at. And she is there saying that in those circumstances, Bailey is a divisible disease case. By a parity of reasoning, we would respectfully submit that in this case, one should be looking at the sepsis, not the heart attack, if I can use a shorthand. And if that's right, one is then looking to see whether the guilty delay was in part, it is reasonable to infer that the guilty delay was in part responsible for the development of the sepsis. If so, the claimant is entitled to succeed to that extent at least, as indeed Mr. Justice Hellman found, as my Lord Hodge observed yesterday. But the next question is, are we also entitled to recover in respect to the heart attack? Well, if it is a case where apportionment is either argued or possible, and of course neither is in this case, then we would probably be entitled to recover only the identifiable proportion of both the sepsis and the heart attack, which is a result of the guilty delay. But whereas is here, apportionment is not argued. That's not my best point. The better point is that it was scientifically impossible to identify which part of the delay caused which part of the sepsis, and which part of the sepsis therefore caused which part of the heart attack, just as we'll see in a moment, in Bailey, Mr. Justice Foskett held that the pancreatitis and the weakness consequent upon the negligent treatment both contributed to the aspiration to the weakness, which led in due course to the aspiration of vomit. But it was quite impossible to say whether one contributed more than the other, or one less than the other, or whatever. So that we respectfully submit that, and if that's right, then as was suggested yesterday, the next question we respectfully submit, following the usual common law approach, is one of remoteness. If it is established by way of inference that the negligence of the BHB contributed to the divisible condition of causation, of sepsis, and that as a matter of usual applications of principle of remoteness, the sepsis led to the heart attack, and it is scientifically quite impossible, as Justice Hellman seems to have found, to identify which part of the sepsis is caused by guilty and which part by innocent delay, then according to usual principles, one would be entitled to recover. So the complaint is, so we submit that is the effect following the approach of Lady Justice Smith within the Atomic Veterans case to Bailey. That takes one on then to the concern that the claimant, the hospital board, voices, which is that if Bonington enlarges circumstances in which a hospital board may be liable, or potentially enlarges those circumstances, then this has dramatic implications in every healthcare case. Well, with respect, that's not right, because the first control mechanism is, of course, the judicial consideration under Bonington of whether the claimant has proved enough to enable the court to draw the inference of partial causation. And in the case of a divisible condition where the evidence indicates that the guilty factor, whatever it may be, has effectively caused no real contribution, of course it's wrong to draw the inference. Likewise, in an indivisible case, where the evidence proves that the cancer was caused more probably by the cancer than by the smoking, as it were, than by the chemical exposure or whatever it may have been, then it would be wrong to draw the inference. So the first control mechanism we respectfully submit is the familiar mechanism, which applies also in what we've called robust but for, which is for the court to consider whether it is appropriate to draw the inference or not. It's the question, I keep saying this, but has the claimant proved enough? And that, of course, requires inevitably a consideration of the whole of the evidence in the case and an exercise of judicial judgment. One of the issues that arises is...
And this is an exercise which the judge didn't take, is that right?
My Lord, yes. Well, it's an exercise the judge undoubtedly didn't take, my Lord. And as for the reasons I've submitted yesterday, the Court of Appeal may have taken. Because, as I was saying, it seems to us...
The judge didn't take it, why? Because nobody suggested it to him.
That's right. I can't resile from that. I can't hide from that. He was, though there is some suggestion, at least, that the judge was being invited, and this is a passage to which I think I took the board yesterday, to consider inferences. I don't take you back to it. It's page 364, red, 271, black, within the transcript. The approach the judge wished to take is at line 16. Given that the burden of proof is on you, if we don't know, am I not obliged to decide the case in favour of the defendants? In other words, it's for you to prove no mention of inference, if I can put it like that, whether it's but-for or Bonington. Mr. Pachai, we're seeing small signs of it right, and the bulk of it is obviously happening around 9 and 10 o'clock, so there's no evidence of rupture in its full-blown glory had already taken place by that time. And obviously by now there's some question of whether it's the beginning. And then he goes on at page 365, line 13, I think it is. Now, if we had a system of the stat immediately within the hour, could it have been done by 12 o'clock? In which case he would have gotten to the surgical room, assuming there was a room available at 2 o'clock or 2:30, which of course being all well within the margin of whether it's 3:19 or 4:43. So I think there is a hint of inference there, but I don't think, reasonably say very much more than a hint. But on the other hand, my better point, my lord, I hope may be that the inference point, the Bonington-Bailey point, is raised squarely in the Court of Appeal. It's dealt with squarely within the respondent's skeleton argument. And they do not at that point suggest that it is wholly inappropriate that the material contribution, whatever that means, test should be introduced at the appellate stage. And it's quite clear that it was being considered within the Court of Appeal in Bermuda. But for the reasons I was submitting yesterday, and I won't endeavour not to repeat myself, we respectfully submit that the evidence is there upon which the inferential approach, whether it be straight but-for or Bonington, could be adopted.
Mr. Brown, I know you say, and you may well be right, we'll have to see, that the sepsis is a divisible condition, so that if, so that all you need to say is whatever else Bonington applied to, it applied to divisible conditions, and here we've got one.
Yes.
Yes?
Yes.
But do you in fact say, with Lady Justice Smith in the Atomic Veterans, that Bonington only applies to divisible conditions?
No, my lord, I don't.
You've made the submission that in an indivisible case the inference may well not be justified.
Yes.
That's an evidential matter.
Yes. No, my lord, I don't. And I'll come to that if I may,
Thank you.
because
That's all I need.
I'll come, if I may, in a moment, to the four control mechanisms for which Maloney and friends contend. That's my word, control mechanisms, not theirs, but the core four qualifications, I think they call it, for which they contend. And one of those, as your lordship will recall, is the divisible-indivisible point, and I'll come to that if I may in a second.
That's fine, thank you.
May I, before doing so, pass on to Wilshire, to McGee, I beg your pardon.
Are you still on your first control mechanism?
Yes. Lady, the way I put it is that because there is always the exercise of judgment by the judge in terms of whether it is appropriate to draw an inference or not, that is the first port of call, as I used that expression in a different context yesterday. But in addition, there are the four overt control mechanisms, of which the divisible-indivisible debate is one. But I hope before coming to that, it may be as helpful to look briefly at McGee. The board will recall that there is a very substantial dispute at the very highest level as to what the House of Lords decided in McGee. On the one hand, there is the dictum of Lord Bridge in Wilshire, with which all the other four members of the House agreed that McGee does not make new law, that it is simply an inference case. And on the other hand, there is the interpretation of the House of Lords in Fairchild, in which, if I can adopt a phrase used by my lady yesterday, they hold in effect that McGee opens the Fairchild box. So there is this very, very clear dispute at the highest level as to what McGee actually decides. I would respectfully submit that it matters not terribly to our submission on Bonington which is right. Because if it's the correct, that Lord Bridge is right, and it's an inference case like Bonington, which we submit is clearly an inference case, then the effect of McGee is that it may be appropriate to draw inferences beyond those which Bonington would itself suggest are appropriate. I say that for this reason, that in Bonington it is clear that there was evidence that the guilty dust was likely to have caused the pneumoconiosis, at least in part, because it's a divisible condition. In McGee, on the other hand, there was no evidence to show whether the brick dust, which had not been washed off in a shower as it should have been, made any difference to dermatitis or not. So if it's an inference case, as Lord Bridge would hold it, then it is an inference based on less evidence, if I can put it like that, than would have been available in Bonington. Now, if that's right, and if that is the correct interpretation, then we would respectfully submit that it simply confirms the submissions we've been making in relation to Bonington and may suggest that those submissions, that the circumstances in which such an inference should be drawn would be rather broader than Bonington itself would suggest. If, on the other hand, the Fairchild interpretation, it's only the majority in Fairchild, but the majority in Fairchild, and I think my Lady Hale in Barker and Chorus at paragraph 123 is right, that McGee opens the Fairchild box, then because we're not trying to put ourselves into the Fairchild box, we would, if we may say so respectfully for a House of Lords case, leave McGee on one side. Because, so that I hope not simply out of timidity, but I don't enter into the dispute about how McGee is to be interpreted, because whichever way it's interpreted, it either supports the Bonington approach, which we've already submitted, or alternatively, it is a Fairchild case and we don't seek to bring ourselves within the Fairchild exception. At paragraph 76 of our written case, we repeat a passage from Clark and Linsell, which is to be found in, I think, volume 6, but it matters not because we've set out the whole passage at paragraph 76. The effect of Wiltshire was that where the defendant's breach of duty increases an existing risk factor, the court could, choosing to take a robust and pragmatic view of the evidence if necessary, infer that there must have been some material contribution to the claimant's damage, i.e., the court may rely on McGee in order to apply Bonington castings. Where, however, the defendant's breach of duty merely adds a new discrete risk factor to the existing risk factors, it is not legitimate to infer that it was the guilty risk factor which probably caused the damage. The proposition is still correct after Fairchild. Well, I think the editors of Clark and Linsell have been a little bolder than I've been in adding that last sentence. But
do we know who wrote it? Which bit of Clark and Linsell?
Lady, I'm sure we can find out. And along with the piece of paper in which I set out the Bonington, I will, if I may, seek to identify the relevant author.
Well, it's occurred to me that the Bonington principle is going to be on the transcript. I mean, the principle you advanced, the point you put earlier, is going to be available. I don't have to write it down because it's going to be in the transcript.
Yes, it will, my lord. Yes. Well,
as my lady pointed out yesterday, we don't very often get...
Yes.
We're not used to this luxury.
It's not a luxury.
With working electronic bundles. And...
Yes, it's not a luxury we're sharing, which is why it didn't occur to me. But I'm very grateful to be let off, if I can put it like that.
You haven't got the transcript, have you?
No, we haven't. It's been paid for by the other side, and you would understand our
Maybe a law against that.
financial position is rather different.
I'm sure that we can share.
I'm relieved to hear that.
I mean, I've always thought it's absolutely disgraceful for a lab transcript not
Well,
to
you
give a
certainly
copy
can't
to
let
a
us have it if you don't let them.
Absolutely.
Since I've already got a copy of it.
I'm grateful for that. We were invited to
In
share.
fact, we did offer it.
Well, we were invited to share the cost, I think, and
Can't afford it.
Yes.
I don't say any more. We've been offered it. That's fine. But
Could I just check up with your Bonington formula? You said that if the scientific or medical uncertainty precludes an answer, the but-for test, the court should consider whether the defendant has caused at least part of the damage. Is that a but-for causation of part that you're talking
Yes.
about? Yes. That's fine, thank you.
may I pass on to? I'm not sure I need say any more about Wiltshire because I have endeavoured to submit that we accept that Wiltshire is correctly decided because that is simply one of a number of discrete factors, all of which add to the risk, but are not together acting so as to produce the condition. Any one of them may have produced that outcome. Court's quite unable to infer which it was, either on the but-for sense, or to infer that the guilty factor probably contributed to the damage. So here I've made the point already. We have dealt with a number of cases following Bonington within our written case. The only point I would make, if I may, in relation to those is that there is a series of cases in which the courts at very high level have considered clinical negligence cases in the context of material contribution and have not all of them have they found liability, but in not all of them, in none of them, have they indicated that one of the reasons for dismissing the case is that it is wholly inappropriate to allow material contribution in the clinical negligence setting, which of course is one of my learned friend's submissions. The first one is rather tiresome. I'm sorry, this should have been written down. It easily could. It'll be in the transcript, of course. The first we respectfully submit is Wiltshire. The second is Brown and Lewisham. That's volume 1, tab 10, page 225, electronic, we think, 1132.
It's working at the moment.
I'm grateful.
Yes?
I don't take you to the fact, lady. I simply submit.
No, I'm merely reassuring you that your page references are correct. So you don't have to say "I think" all the time.
Well,
You have a series of 3 now.
I'm suitably reassured.
Yes.
Bailey is a third. Hodson and East Berks is a fourth. Ramond and Area Rose a fifth. I would also draw attention, if I may, to Wright and Cambridge Medical Group. That the lead judgment there was given by Lord Neuberger, and he describes at page, it's volume 5, tab 57, page 1858 paper, and 2935 electronic. Go to that if I may. Tab 57, as I say, 1858, I think. Where that's a case where, as the board will recall, the general practitioners were late in referring a claimant to a hospital. The hospital then failed to carry out the appropriate treatment, partly because it was a weekend. And the question was whether the failures of the hospital effectively expunged the causative potency of the failures of the general practitioners. And in reaching his conclusion, Lord Neuberger says at paragraph 36, and extraordinarily, the hospital was never joined in the litigation, so the only defendant was the general practitioner. But at paragraph 36, Lord Neuberger deals with the question of synergy, if I could put it like that. In the present case, I consider that the defendant's, that's the GP's negligence, was a causative factor of the claimant's permanent injury. In other words, as in Rahman's case, I have concluded that the negligence of the defendants and their failing of the hospital had a synergistic interaction in that each tends to make the other worse. And accordingly, it seems appropriate to proceed on the basis that both were causative of the damages suffered by the claimant. Now, I accept immediately that Wright and Cambridge Medical Group is not expressed as being a material contribution case, though the board may have observed that Sarah Green thinks it should have been. In any event, the other 5 cases are all, we respectfully submit, clinical negligence cases where material contribution squarely arose.
Is there a difference between saying a causative factor of injury and a material contribution to injury?
That, if I may say so, is the difficulty one faces when one comes to the question of the way in which the words are used, because it seems to me, with respect, that Lord Neuberger certainly analyses the case upon the basis that that is but-for causation. He concludes that that is a necessary factor, was a necessary factor to lead to the damage, and therefore this is a conventional but-for case. Sarah Green, at volume 6, tab 63, electronic 3102, I don't go to it, suggests that it should in fact be analysed as material contribution rather than but-for causation. But
Why is that?
But I thought we were in material contribution as an aspect of but-for causation.
yes,
Otherwise, I've misunderstood most of what's been said.
no, exactly. And the difficulty is, and I'll come back to this if I may when we come to Bailey, the difficulty is that so many of these cases could actually be viewed probably either way. In other words,
But what is the difference?
the difference in principle, my lord, is this: whether you can say that it is that the claimant has proved that the negligence, to use a shorthand, was a necessary cause of the whole of the damage, in which case it's conventional but-for, or whether under Bonington the claimant alternatively proves that the damage caused a part, and that then leads into the issues about apportionment and so on.
The negligence was a necessary cause of part of the damage.
Yes, Lord, that's a better way of putting it, if I may respectfully adopt that phrase. Yes,
That's what you say material contribution means.
that's what.
Plus
we
your
say.
robust inference point.
Yes, that's what we say material contribution means in this context, and that's where Bonington gets you. Whether that gets you home completely, for the reasons I've already submitted, will vary. In other words, in Wright, Lord Neuberger was concluding that the negligence of the general practitioner was a necessary element of the whole of the damage. In Bonington, the House of Lords was concluded that the negligence was a necessary contribution only to part of the damage, but it was then impossible to work out which part was which, so that the risk fell upon the defendant, not upon the claimant.
Where the negligence in question comes first in time, which it did in Wright, you will often get an analysis in terms of the break, whether there's been a break in the chain of causation or not, and indeed that was part of the reasoning in Lord Neuberger's speech clearly in Wright. Is that simply asking the same question, do you say, or is it different?
We respectfully submit. It may be is the answer. I'm sorry, that's a hopeless answer. But the way in which, and this is why we respectfully submit, the way in which Lord Neuberger has approached the problem in the Wright case is of assistance, because of course it can be the first. To take a very simple example, someone renders someone with an unstable spinal fracture in a car accident. He's taken to hospital. Hospital failed to spot it, so the unstable fracture turns into paraplegia. Now, unless it were an error of the highest possible order by the hospital, it is inevitable in those circumstances that the person who put him in hospital will be found to some extent at least responsible. There are other circumstances where the one...
Or no break in the chain of causation, you mean?
Yes, yes, exactly. That's why I say the highest possible negligence on part of the hospital. Completely, it's an actus, novice actus. It's completely
Somebody
unforeseeable.
else's subsequent negligence is
Yes.
not necessarily a novus actus. That must be right.
Precisely. I mean, it may be, but it's a very, very heavy burden for the first tortfeasor to discharge, to establish that the second tortfeasor's negligence of it alone caused the injury. I mean, I suppose it might be said that if someone in the first accident caused a cut to a finger, and that was then allowed to develop into gangrene, which led to, or cut to a leg might be a better example, which was allowed to develop into gangrene over a substantial period of time.
If they amputated the wrong arm.
Well, precisely, or the wrong leg, or a very small cut to a toe ends up in amputation of the leg, or something of that sort. But it needs to be a new negligence of a very, very high order to break the chain of causation, where, to, I hope, deal with Lord Hughes's question, the negligence of the tortfeasor, that tortfeasor comes first. It's very rare that the negligence of the second tortfeasor will expunge any responsibility, if I can use that word, in relation to the first tortfeasor. But there are cases, of course, where it could happen the other way around. I mean, one of the suggestions that was being made in the, forgive me a moment, which is the case of the chap who took the taxi drive, right? The chap who took the taxi ride? Brown and Lewisham. Yes, Brown and Lewisham, I'm grateful. Is the case where the claimant was discharged, and then he took a taxi drive, and it was suggested that it was the taxi, that he should never have been discharged and allowed to take the taxi drive. So the negligence actually came second after the earlier problems. And the court there was looking at it and saying, well, that is a potential cause, but on the evidence it isn't. So the sequence, in a sense, and we'll come back to this when we come to what I've called the four control mechanisms, doesn't matter. The critical point is that they should act together and synergistically. May I then come immediately to those preconditions? They're dealt with, or control mechanisms, I call them, they're dealt with within the written case at 81.2.
It is worth, I think, pointing out that in paragraph 30 of Wright, Lord Neuberger refers to the GP's causation argument as raising two questions. The first is whether, on a fair view of the facts, the defendant's negligence was a cause of, or to put it another way, significantly contributed to the claimant's permanent injury. Yes. So he's obviously talking about material contribution.
Well, lady, as sometimes happens, it's quite difficult to see whether the material contribution is a but-for.
Oh, it undoubtedly was.
A robust but-for material contribution, or whether you're looking at a Bonington material contribution.
Well, I call Bonington a robust but-for. I thought that was your argument.
Yeah, well, lady, it is. But I'm sorry, I'm not making myself clear. Our argument is this, that in a case like Wright and Cambridge, on the way that Lord Neuberger has approached it, the first defendant, the general practitioner's negligence was a part cause of the whole of the damage. In Bonington, we respectfully submit, you get the alternative position that it is a cause of part of the damage, but it is not possible to say that it is a but-for cause of the whole of the damage, in other words, a necessary cause of the whole of the damage. And that, we respectfully submit, is why Bonington is different.
Thank you.
And that, my lady, is why, in a case like Wright and Cambridge, the claimant recovers the whole of the damages in Wright and Cambridge because he is a joint tortfeasor in respect to the whole of the damage. in a case like Bonington, he doesn't automatically become responsible for the whole of the damage as a joint tortfeasor in respect of the whole of the damage, because he's not responsible for the whole of the damage. He's responsible only for part, and therefore there is at least a potential for apportionment. But apportionment is either not argued or is impossible scientifically, in which case one then raises this question, we respectfully submit. Given that the claimant can prove only a part of the damage, but nobody knows which part, should the court in justice then say the claimant will not recover at all because he hasn't proved his case? Or does the court in justice say, you, the defendant, have been found to be in breach of duty in whatever respect it may be, and it is appropriate in those circumstances that you bear the burden of the scientific impossibility rather than the claimant? So, lady, I'm sorry, I'm not making myself...
No, you have now.
Well, I'm grateful for that.
Maybe it was me being slow.
I'm sure not. Can I come to the preconditions? They're dealt with within the appellant's...
Well, you set out the appellant's four preconditions in paragraph 81 of your case.
We do, Lord. And I'll come to those if I may. We put forward at 82 an alternative formulation. It seemed to us that it probably wasn't very helpful to pursue that to any great extent. It's there for the court to consider as an alternative way of looking at it. But it may be more helpful, I hope, to look at the way in which the claimant puts the qualifications. The first is proven contribution to injury. We respectfully submit we agree with that, but of course the question is, how is that proved? Is it enough to establish an inference of contribution? We respectfully submit clearly that it is, and that such inference is established here. Concurrent contributions, I think I've just dealt with that adequately. We respectfully submit that there does not have to be, as the hospital board suggests, temporal concurrency. It is enough that they are operating together, or, to use Lord Newberger's word, synergistically. The next is single causative agent, and I think I need say no more than that the claimant, the hospital board, at paragraphs 30 to 35 of its written case, deals with the criteria which are effectively, at 33, the contributing factors have to operate in substantially the same manner, page 30, paragraph 33, page 11 of their case. And then, perhaps a development at the same point, at paragraph 35, last two lines, they do need to contribute to the same pathological process which has been identified as the injurious one. We respectfully agree. They must act in substantially the same manner and as part of the same pathological process. We respectfully submit that quite clearly the guilty and the innocent delay here fulfill both those. Indivisible injury, to come to that point, and we deal with the indivisible injury within our case at
7.
127. Thank you. 107, yes, I'm grateful. We would respectfully submit that it is clear, as we say at 111, that the material contribution test has been used in Simmons, which is a psychiatric injury case, and as Lady Justice Smith said in her article in volume 6, an indivisible injury, what she says, an injury which is indivisible par excellence, as a case where the claimant has established material contribution in the Bonington sense.
What was the psychological injury in Simmons? Just very, very briefly.
It was effectively a breakdown consequent upon stress at work.
And that's regarded as indivisible, is it?
Well, that is
I haven't entirely got into my head what the difference between divisible and indivisible.
But Lord, I just, let me attempt
If you could tell me.
Let me attempt it. An indivisible injury, one way of looking at it is it is binary. You either get it or you don't.
Cancer.
Cancer being the obvious example. You either get bladder cancer or you don't get bladder cancer. Psychiatric injury, going back to Bonington, pneumoconiosis, you get levels of pneumoconiosis. So it could be said, well, you would have had a bit of pneumoconiosis because of the guilty dust, you've got more silica, you've got more pneumoconiosis because of the non-guilty, the non-guilty, whichever way around it is, part and part, and therefore you can say, well, as long as the science will help me to divide between the two, I can apportion. That is a divisible injury. Likewise, we respectfully submit, going back to this case, sepsis, we respectfully submit, is a divisible injury. You can have so much sepsis or more sepsis, which tips you into a heart attack. You can
Psychiatric injury is divisible on this.
Well,
This is...
lady, I'm very conscious of Hatton, if I may say so.
Yes, I know, but Hatton wasn't about this, was it? No.
No, not. Well, it certainly wasn't on this area. But your ladyship was, I think, took the view in Hatton that psychiatric injury was in principle divisible, whereas Lady Justice Smith in.
Yes, I think I did.
Yes, well,
I think I do.
It might depend, mightn't it, on the type of,
Yes, it
of
could.
condition. But I mean, any psychiatrist, I suspect, would tell you that there are quite a lot of psychiatric conditions which may be mild, grave, or
yes,
very much serious.
Well, with Lord, with respect, I agree, and it does seem to me that, as it were, it's rather presumptuous, but my Lady Hale
Say whatever you like.
in Hatton may have been considering the case where the individual was displaying some psychiatric symptoms and, for instance, having a few days off work already, and then got that much worse, so they had to go off work completely. Now, you can see that, leaving aside considerations of sick pay and so on, that in that case, you would be saying, well, the psychiatric injury is divisible. On the other hand, in the Simmons, case being considered by Lady Lady Justice Smith, what happened there was that the claimant, to use what I fear is a psychological term, was coping until the stress at work occurred. There were stressors in the background, matrimonial and others, but the individual was coping until the final stress was added, which was the stress at work. And that turned into a nervous breakdown, a complete collapse, and an inability to cope.
Well, that's an eggshell skulls case, isn't it?
That, Lord, if I may say so, is one of the difficulties that bedevils this area of dispute. That very often, and I'll come back to that when we get to Bailey, but very often it's actually very difficult to know which box. Sorry.
Well, you're nearly up to the hour that you promised us
I know I
yesterday.
am. I'm so sorry.
No, it's
been
my fault.
mildly diverted from my path. That's not in any way.
So, speed up, please.
Yes, I will. So, Lady, we respectfully submit that the divisible-indivisible debate, for the reasons we've expressed, can I just give you two further references? Paragraph 90 in the opinion of Lord Phillips and Sinkovich appears to consider that material contribution certainly applies to indivisible injuries. And Lord Roger in Barker, at paragraph 90, likewise, appears to arrive at a similar view. So may I pass on then to Bailey? Bailey is to be found in volume 7, the core bundle, tab 1, page 2171, electronic 3252.
Sorry, could you just give the reference again?
Yes, of course, my lord. It's volume 7, the core bundle, tab 1, 2171, electronic 3252. The facts of the case, I'm sure, are well known. The approach of Lord Justice Waller is to follow the guidance of Lord Roger in Fairchild as to ward law. That is at paragraph 129 I'm sorry, it's Lord Roger at paragraph 129 of Fairchild, it's Lord Justice Waller at paragraph 43. I'm sorry, I can't read my note. The judgment of Lord Roger said this, I don't take you to it, the idea of liability based on wrongful conduct that had materially contributed an injury was therefore well established long before ward law, but ward law became a convenient point of reference, especially in case of industrial disease. In such cases, this basis of liability is of considerable importance, since it is enough that defendant's wrongful act materially contributed to the claimant's injury. The law is not applying the causa sine qua non or non or but for test of causation. In ward law, for instance, the pursuer did not need to prove that, but for the dust from the swing hammers, he would not have developed pneumoconiosis. All he needed to prove was the dust from the swing hammers contributed materially to the dusty atmosphere which he breathed and which caused his illness. So, my lady, we would respectfully submit that effectively that is the approach which we are advocating so far as this is concerned. The critical point, though, it's clear, we respectfully submit from the opinion of Lord Roger, that he is...
Well, Lord Roger is consistent with himself.
yes.
But that doesn't mean to say that he is consistent with everybody else who's expressed.
No, I'm sorry, my lady. I'm expressing myself badly. We are respectfully submitting that the approach Lord Justice Waller was adopting, following Lord Roger, we respectfully submit is consistent with the approach which we submit is the correct approach to Bonington. The claimant proceeds upon the basis that Bailey is to be interpreted, or the appellant, is to be interpreted as a case where liability was established only by proof of a material increase in risk. That, we respectfully submit, is based upon a rewriting of what Lord Justice Waller said. What is suggested at paragraph 48 of the appellant's written case is that the effect of Bailey is that a claimant may be entitled to damages for an injury where all he can prove is that the breach has caused something to occur which may or may not have had any effect on the injury. In other words, it's a material increase in risk case simpliciter. With respect, that's not what Lord Justice Waller held. He held that medical science, and this is at paragraph 46, it's the very end of the judgment, just below D. If the evidence demonstrates that but for the contribution of the tortious cause, the injury would probably not have occurred, the claimant will obviously have discharged his burden. In a case where medical science cannot establish the probability that but for an act of negligence, the injury would not have happened, but can establish that the contribution of the negligence was more than negligible, the but for test is modified and the claimant will succeed. So where the Lord Justice Waller has held that there is evidence to justify a conclusion that the negligence actually contributed. So to say, as does the appellant in paragraph 48, the position is that Bailey says there's liability where there's breach which may or may not have had an effect on the injury with respect is inappropriate. There is a clear conclusion that there was an effect on the injury. Lady, conscious of time, I would respectfully indicate that our position is that so far as Bailey is concerned, the judge's findings of fact, which are to be found at paragraphs 28 and 33 of the Court of Appeal decision, were quite clearly that it was reasonable to infer that the breach of the hospital authority, or Ministry of Defence, was still a material cause of the weakness at the point at which the aspiration occurred. It was appropriate to infer that the breach, that the weakness was the cause of the aspiration, but that it was quite impossible to say that, to apportion between the underlying non-negligent condition causing weakness and the negligent condition causing weakness. That, we respectfully submit, would be an appropriate finding, appropriate approach following Bonington. Where the claimant, or the appellant, complains is that in the last sentence of paragraph 46 of the judgment of Lord Justice Waller, he says, I've read it once, but may I read it again? In a case where medical science cannot establish a probability that but for an act of negligence the injury would not have happened, that can establish that the contribution of the negligent cause was more than negligible, the but-for test is modified and the claimant will succeed. We respectfully submit that if that passage can be criticised, the criticism lies in the fact that it does not deal with every step of Bonington, because it appears to conclude that you simply go from a more than minimal contribution to liability, and liability in full. We respectfully submit that's not right, that what the court has to look at is to see whether it is reasonable to infer on the whole of the evidence whether that material cause is sufficient. It's of course got to be more than de minimis, but usually in the exercise of judgment the court will be looking for more than that before it will draw the inference. And we would respectfully submit that insofar as it may be appropriate to criticise Lord Justice Waller, it is the elision of those different steps in which the criticism may lie. I promised to come to the article of
Professor Stapleton, I think you mean.
I beg your pardon, Lee?
Professor Stapleton.
Professor Stapleton, I'm so sorry. And I'll take this, if I may, conscious of time, as quickly as I can. It's to be found, my lady, in volume 6, tab 662071, electronic 3151. May I simply invite your attention to page 2071, where the thrust of the article is summarised. Second paragraph. This article argues that a preferable approach for private law is a clear recognition of a general principle that all that is required before the relation between a factor and the existence of a phenomenon will be recognised as causal is that either, but for the factor, the phenomenon would have been prevented, or the factor resulted in some positive contribution to the relevant mechanism by which the phenomenon came about. In other words, that when determining what it means to be a cause, private law should adopt a notion of a cause that is wider than the relation of necessity that is encapsulated in the but-for test. For simplicity, the discussion will focus primarily on claims in tort of negligence and so on. So that's the thrust of the article. And I go on, if I may, to the consideration of Bailey. And that starts with page 2082, electronic 3162, I think. That's because I can't read my writing rather than because I'm uncertain of the numbering. May I look then at 2082? She starts by considering the findings of fact and approach of Mr. Justice Foskett, and concludes that because the conclusion is that this is picking it up in the second paragraph under Bailey, the breach resulted in a positive contribution to this weakened state, so she be recognised as having made a causal contribution to the mechanism by which this indivisible injury came about, regardless of whether it had been necessary for that threshold to be reached. Once it is acknowledged that such an unnecessary factor may contribute to the occurrence of an indivisible injury in this way, it becomes clear that no special rule was needed to assist the claimant in Bailey to establish the breach was a cause of her brain injury. The development there, of course, is that if it wasn't a necessary cause, conventional but-for can't apply. It's what she calls, I think, an overpopulated step. In other words, you've got so many different causes there that you really can't say whether one is a necessary one or not.
Well, her thesis is that it doesn't matter.
Yes.
Her thesis is that that you may well have caused an event even if it would have happened without you.
Yes.
Yes. And she's not saying that there are so many causes. What she's saying is there is a causal mechanism which already has and may already have an adequacy to cross the but-for threshold, but nonetheless the tortfeasor has contributed to that causal mechanism hence she speaks of unnecessary causes.
Yes.
I.e. you've got the but-for threshold already, and you contribute further. But
Yes, yes. But, look,
But don't forget that the quid pro quo in her argument, which is, some might think, starting with a blank sheet of paper rather than with authority, that the quid pro quo is, yes, you may have caused something which would have happened even if you hadn't been there,
yes.
but when it comes to the assessment of damages, the plaintiff is likely to fail against you.
Yes,
So
well,
the question is shifted from
Exactly.
causation
Yes.
into damages in her analysis.
exactly so.
Yes, yes. But Lord, I accept that. But having been asked to deal with it, I felt it was...
It was because of her analysis of Mr. Justice Foskett that I wanted you to look at it, because what she seems to be saying is that at first instance it wasn't, but for causation wasn't established. But her unnecessary causation was, but it may not matter.
Well, Lord, it's with respect, and I don't want to waste time on it, but as one looks at Mr. Justice Foskett's findings of fact, and I've invited your attention to where those are to be found, it's quite difficult, with great respect to him, to see why he resorted to material contribution at all. It seems to me that where you infer that the negligence caused the weakness, you infer that the weakness, and that it was a remaining cause of the weakness at the point at which the aspiration occurred, and that the weakness led to the aspiration, but you can't say how much is pancreatitis and how much is weakness. Leaving aside the overpopulated step point, it's quite difficult to see with respect why that is not a but-for causation case. But in any event, we respectfully submit that if it is to be regarded, as Lady Justice Smith does, as a divisible injury case, and you've got to look at the weakness before you look at the aspiration and the brain damage, then one can see that Bonington would entitle you to succeed in any event. Well, I don't want to go into the detail of it, but we would respectfully submit that when one comes to look at the analysis of Professor Stephenson in relation to Bonington, which is to be found at pages 208, 5, she is effectively saying that Bonington is either simply the usual case, that if you can show that there is partial causation, then you recover for that bit, if I can put it like that, and that's it. Or it is going on to the next stage of saying that Bonington, in addition, it entitles you to succeed in full in the limited circumstances to which I have adverted, namely scientific impossibility of division, and that, of course, did apply in Bailey. Or you have the apportionment argument is not raised. One hardly thinks that would arise.
Where does she deal with the impossibility point?
The impossibility, my lord, is page 2084.
Yeah.
May I pick it up about 8 lines from the bottom? Bonington may represent a departure from the latter qualification step of this orthodox approach in the context of a particular evidentiary gap, namely where it is known that the victim's total condition is a divisible one, but there is no acceptable evidentiary basis on which the disability due to the separate insults of the body could be apportioned to the individual. The claimant is allowed to recover for the total condition. And then she summarises her views, if I could simply give you the reference, from page 2085, last partial paragraph, to the top of page 2086. So, my lady, we respectfully submit that Bailey is to be regarded either as potentially a but-for case, or more likely, is in fact an application of the principles in Bonington for which we contend. But it does not mean, as my learned friend was submitting yesterday, that takes you straight into material, the health authority becoming liable for the whole of the damage in every case in which more than minimal contribution is proved. It has got to be, I'm not going to repeat myself, the inference point and the control mechanisms and so on. It's much more than that, and that's where, if Lord Justice Waller is to be criticised, that's where it arises. Lady, may I pass over, therefore, procedural points and no finding of scientific uncertainty? We deal with that in our written case, paragraph 124 onwards. I would only deal with policy so as to indicate that there is, of course, always the tension between finding for a claimant who may not have suffered the entirety of the damage consequent upon the negligence and finding against a claimant where it is established that the negligence has caused part of the damage, but no one can say how much. And we respectfully submit that when one looks at the multiple tortfeasor cases, the shooting cases, that area, where the law is very clear, we respectfully submit, that you're entitled in a multiple tortfeasor case to recover in full against all the tortfeasors, but then it's a matter of apportionment. And it would be very surprising if this area were different. Lady, lastly, and I'm sorry to impinge on our comparative law, and I won't spend any time on that, save to say this, that so far as
if you have a multiple tortfeasor case,
Yes.
then you can recover in full against both.
Yes.
Whereas if you have, if one of the causes is innocent dust or whatever, then what?
Well,
is there then scope for apportionment? Why doesn't the same principle apply? That you can recover the whole lot from the one tortfeasor?
Well, we respectfully submit that in a non-but-for causation case, unless there is scientific uncertainty, so you simply can't tell whether the innocent is responsible for more and the guilty for less or vice versa, following Bonington and following Bailey, no apportionment cannot take place. But in the majority of cases, it is possible, and words rough and ready spring to mind, but they're actually used in the authorities, in a rough and ready sort of way, to say how much is down to the innocent, how much down to the guilty, and to apportion.
But that doesn't apply, though, in a double tortfeasor case.
Yeah, but Lord, it doesn't, because it comes at a different stage with respect.
Well, because you've got, the point is that joint tortfeasors are jointly and severally responsible for the whole.
Yes, absolutely.
So the apportionment arises.
Comes next.
I'm so sorry. The apportionment arises, my lord, but it arises at the next stage.
Yeah.
You find both tortfeasors liable in full, joint and several liability, as my Lord Hughes has said, but then you apportion. But again, the effect of that, of course, is that the policy is that if anyone's going to lose out, it will not be the claimant. Because if one of the defendants is uninsured or impecunious, you can recover against the joint tortfeasor who is insured and has money. So if I may say so, that's an argument in favour of the proposition for which we contend, which is that if there is to be a policy consideration, the policy consideration in other areas of the law closely related to this one is that if anyone's going to lose out, it will be the defendant, not the claimant.
But where there is scientific uncertainty, but the causal mechanism is but one mechanism, namely the delay allowing the sepsis to develop over time, why shouldn't legal policy say, well, once we ascertain the extent of innocent time and the extent of guilty time, we apportion the responsibility to the guilty person in that proportion? Why would that be a bad policy?
My Lord, because it's the nature of the way in which sepsis develops with respect. Because in this case, one can see that the innocent delay, can I go back to the timings I was using yesterday?
But this is on the basis of scientific uncertainty. You may say there isn't scientific uncertainty because we know how sepsis develops.
Yes.
But if the hypothesis is that you visit 100% on the defendant because of scientific uncertainty, why not be rough and ready in this allocation of responsibility for delay?
If the science permits you, as it did not in Bonington, to make an apportionment, and it's raised, then if I may say so, I think I'm right in saying that your lordship must be right. But where the science simply either makes it clear that it's very unlikely that there would have been going back to this case, that it's very unlikely there would have been sufficient sepsis at 5:15 to do any damage at all to the heart, and that it is apparent on the evidence that all the relevant sepsis occurs after the innocent delay has ended, then quite clearly there's no scientific uncertainty. And I'm sorry, I'm repeating where I started yesterday, but we respectfully submit that that is this case where one considers it.
I was testing your scientific uncertainty point. You're saying in this case, because of your reading of the findings of fact on timing, that 5:15 was the critical cut-off.
Yeah, Lord, I think perhaps a better answer to your lordship's question would have been this. It depends on the extent of the scientific uncertainty. If one is saying it is simply impossible to know, as Mr. Justice Foskett was in Bailey, how much is innocent, how much is guilty, then obviously injustice is going to be done to someone, because there must actually be an answer if we knew enough science to know it. But we simply don't know what the answer is, and we can't even get anywhere near an answer to it. And in those circumstances, the policy comes in, which I respectfully submit is similar to the joint tortfeasor policy. Who pays? Who suffers?
It is important, isn't it, to distinguish between apportioning the damage and apportioning the conduct.
Yes.
One of the things about the law of tort, or especially negligence, is that there is no necessary relationship between the extent of the blameworthiness and the extent of the damage for which you're responsible. Yeah. And that is one of the complaints. But it is a feature of the law of negligence. And so it's a bit oversimple to say we apportion the liability for the damage in accordance with the extent of the blameworthy conduct, because that is not comparing like with like, unless you can say that there is a direct linear relationship between them. You know, quarter an hour's development of sepsis, half an hour, etc., which would be very difficult to say.
Yes. Well, Lord, I respectfully adopt that, yes.
It becomes even more difficult when you then go on to the next stage, identifying the sepsis as the cause of the ischemia. The ischemia precipitated the heart and lung difficulties.
Yes.
But while ischemia may be a divisible condition in the terms that you've been using it, myocardial infarction is not.
Yeah. That must be right, which is why one, but as I say, as I've already submitted, fortunately we submit in this case that that is not a problem which actually arises on the facts of this case. I think I made the submission, so far as comparative law is concerned, we cannot trace any consideration of the Bonington line. There is substantial consideration of the Fairchild box, if I can put it like that, and rejection within certainly Canada of the Fairchild box. It's to be observed that within resurface, Chief Justice McLachlan suggested that the Fairchild exception might go a little bit further than she says in Clements, but that doesn't apply to this case, so it's irrelevant. But what is particularly to be observed, we respectfully submit, from the Canadian cases, is that the continual assertion that robust and pragmatic adoption of the but-for approach is the starting point in all these cases where it is impossible to say but-for on the evidence, yes, or but-for on the evidence, no. So it does, we respectfully submit, strongly support the suggestion of the starting point for which we have contended. I'm sorry I've overrun the hour, unless there are any particular points on which I may be able to assist.
I think you've had plenty of opportunity to assist us with the things that have been troubling us. Thank you very much, Mr. Brown.
May it please, my lady.
Well, does your learned junior wish to follow?
I'm so sorry.
Simply to add, the board asked for the name of the author of Clark and Linsell, the passage to which we referred. It's Michael A. Jones.
Oh, right.
That
Yes,
answers that
yes,
question.
yes. I thought it might be. I just wanted to be reassured. We know the authors of all the articles, and we can compare their comparative authoritativeness. It's useful to do that with Clark and Linsell as well. Yes, Miss Harris.
Lady. May I deal with some of the points that have just been raised in reverse order? My Lord Hodges' point about proportionate recovery. There are two potential control mechanisms to deal with the problem of unnecessary clauses. One is the proportionate recovery method that my Lord Hodges has suggested. But as my Lady Hale has also identified the difficulty with that, especially in scientific uncertainty, how do you proportion it? Because of the difference between responsibility for conduct and responsibility for damage. And so in practice it would be impossible in some cases, because you do not have that linear relationship. You don't have it in cancer, you probably don't have it in this kind of sepsis case. So an alternative potential control mechanism to avoid the injustice of the defendant picking up the whole tab if all they do is contribute in terms of conduct is to tighten up on the foreseeability law. So you impose a filter upstream of the damage. The reason for suggesting that, my lord, is because the plaintiff's argument is because the injury has occurred within the area of risk, so the wrongdoer has created a risk, the wrongdoer should pay. The problem with that in clinical negligence, indeed injury generally, is that because of the effects of Hughes and the Lord Advocate, almost any breach is going to result in a physical injury. So even though the mechanism of injury may be completely unforeseeable, because of the effect of Hughes, the wrongdoer will be liable. That case is raised both in Brown and Lewisham and in ST. Brown and Lewisham was put in by my learned friend, but the point is, and I won't take the board to the references, but in Brown and Lewisham, the claimant was sent home negligently from Guy's. He should have been kept in because he had a chest infection, or an infection of some kind. He was actually sent on the train back to Blackpool, and there was a negligent delay in diagnosing the DVT. And the claimant sued for the consequences of the DVT, which was significant injury. And the Court of Appeal said, well, they raised the scope of duty argument and said, well, it would be wholly wrong to hold the defendants at Guy's liable when the reason they should have kept him in was chest infection and the mechanism of injury was completely unforeseeable. Nobody would have ever predicted it. That argument was then considered in ST, and all of the authorities, and there are a few, which deal with this scope of restricting the scope of duty in clinical cases. And she held in ST that it didn't work to prevent ST, and ST was the dehydration and the thrombosis case. And the defendants argued, well, the mechanism of injury was completely out with anything that the doctors would ever have considered might have resulted from dehydration. And therefore, they could not be held liable merely because of the injury that actually occurred. And it was held, the foreseeability and scope of duty point didn't work because dehydration could lead to all sorts of injuries, including cardiac arrest, which could thereby secondarily give rise to brain injury, albeit via a different route. So I hope that deals with the difficulties of the claimant's argument, which is, well, the wrongdoer should pay two potential control mechanisms, either proportionate recovery or tighten up on this foreseeability point. There is no easy way that we have been able to think of addressing the injustice of a defendant who can't be shown to have contributed to the outcome, but who has been careless, we can't think of a way of addressing that injustice except by means of applying but-for test. If I can deal extremely briefly with some of the cases that have been discussed this morning. One is Simmons, and with respect, that was not a stress at work case. It was a physical injury in the workplace, which then resulted in the claimant getting very angry and developing a secondary psychiatric injury in response to his treatment by the employers. It was all about remoteness. So he did suffer psychiatric injury, but that wasn't the primary injury, it was a secondary consequence of the original physical injury. And I accept that so long as the claimant can prove that the breach is a but-for cause of a psychiatric injury, that he or she should then recover because it's a necessary cause of an indivisible injury. So I accept that. Wright in the Cambridge Medical Group was within material contribution to injury because in effect there were two tortfeasors. And on Professor Green's no breach analysis, which is set out in the article, it satisfies her no breach analysis test. An alternative way of looking at it is it was a Cook and Lewis situation. You knew that there were two tortfeasors. You knew that with proper conduct by both of them, she wouldn't have suffered the injury. So on either analysis, the result was correct. Sinkovich was raised. My Lord Clerk was puzzled entirely understandably with respect by the divisible-indivisible injury. The paragraphs which may help, and I won't take the board to them, are paragraphs 12 to 17 of the judgment, the opinion of Lord Phillips in Sinkovich, which is electronic page 3407 and hard copy 2326 to 7, paragraphs 12 to 17. May I take the board, please, to volume 6, tab 66, page 2087, electronic 3167 to 3170.
Why don't we have the law report of Sinkovitz?
I was puzzled about that, and I'm sorry, my lady.
Yet another problem. There are several cases where we don't have the law report.
Well, some of them are in volume 8, but I don't believe that. Oh, is it in volume? It is
666.
volume 5, tab 48, I'm told.
Stapleton's art.
Well, never mind.
Yes, anyway.
I'm just making another grumble.
Well, I confess that I thought we had, but when I looked again, I realised we didn't. 6, what's 6?
It's a policy issue.
I'm not trying to put you off, Miss Harrison. I'm trying to communicate with those behind you.
Well, I'm like, well, I am sorry, my lady. Electronic 3167 to 3170, 2087, hard copy. This deals with, I hope, my Lord Hodges' point raised yesterday afternoon with my learned friend, and also with my Lord Toulson's point about proof and query evidential proof yesterday. We rely upon and adopt this analysis. At the bottom of internal page 55, 2087, hard copy. But the estate must establish, this is in the syringe case, the estate must establish inter alia that the death represents damage. The patient is not entitled to be better off than he would have been in the absence of tortious conduct. It's the claimant who bears the burden of proving that the injury to which the breach contributed represents damage in the sense set out above. Because in the cases under discussion, this issue depends on an actual fact that existed in the past, namely the extent of non-tortious contributions to the relevant threshold step in the mechanism. The damage issue must be proved on the balance of probabilities. Specifically, the claimant must prove that, more likely than not, the victim would have escaped the indivisible injury had there been no tortious conduct, because the non-tortious contributions to the threshold step would alone have been insufficient to reach the threshold. So if in the overdose case it was clear that prescribed dose alone would have been sufficient to kill this particular patient, the conclusion would be that while the tortious increment of the overdose was a cause of the death, that injury did not represent damage, so no damages are recoverable. And then she respectfully suggests that Lord Phillips was wrong to suggest the alternative in Sinkovich. And at the bottom of that paragraph, just above the heading, impossibility of proving damage, Professor Stapleton says, this analysis reveals that the problem facing the claimants in both Hodson and Bailey was not establishing that the breach continued to the occurrence of an indivisible injury, but was because the claimants in these cases could not prove that on the balance of probabilities, this injury represented damage.
Yes, so as Lord Hughes says, Professor Stapleton shifts the problem from causation to damage.
Yes, absolutely. And
It remains the same problem.
exactly, my lord, and that's why Lord Hoffman in a number of articles says, well, it doesn't really help very much, just adds an air of complexity. But nevertheless, the point is, the proof has to be on the balance of probabilities, and it has to be on the plaintiff or the claimant, which answers my Lord Toulson's issue about whether the defendant effectively has to prove the reverse. And even if one says it's an evidential burden, the effect is in scientific impossibility. The effect is the same, whether it's evidential or legal, and that's wrong. The other reference in Professor Stapleton is over the page at 2089. I won't read it, but I will invite the board to look at it. It's the paragraph immediately under the heading of impossibility of proving damage, over onto the first 4 lines of the following page. So, that, I hope, deals with the unnecessary cause point. Now, the reason why inference doesn't work in this case is as follows in our submission. Here, we know, but all we know, is that sepsis per se is risky. It may lead to injury, or it may not. But per se, it is not the damage in respect of which the plaintiff was suing. We know that for 2 reasons. One, because his particulars of claim specifically pleads cardiac injury. And 2, because it wouldn't make sense to be pleading in respect of the sepsis if it hadn't gone on to cause damage. There's the plural Plucks case, but also, if that were right, both Hodson and Gregg would be wrong. And the reference is to my Lady Hale's judgment, opinion in Gregg and Scott.
Yes, it was an opinion in Gregg and Scott.
It was an opinion, yes, exactly.
But Lord Phillips in Sinkovich was a judgment.
Oh, well, my lady, unfamiliar in this territory as I am, I'm very
Once we became a court,
right.
we started to give judgments.
Judgments.
When we were a committee of the House of Lords, technically we gave speeches,
Yes.
but when they went into writing, we tended to express them as opinions.
Thank you, my lady. Yes.
Little lesson for you all for the next time.
I'm always eager to learn, my lady. Thank you. So the next time I'm here, my lady.
So it was right, it was an opinion.
Thank you, my lady. The page reference is 2263, paragraph 200, F2H. In the electronic is 3344. Greg, I hope, is in the
Should be in the
core bundle.
core bundle, it is, I think.
Tab 4, paragraph 200. Bottom of the page. This argument, and it refers to the argument at paragraph 199, which is the quantification approach. The claimants had argued that physical injury in the shape of the spread of the cancer in late 95, and the losses that he then suffered thereafter were consequential. So it was a remoteness of damage point, and that argument was rejected at paragraphs 199 and 200 by my Lady Hale. So that's why the sepsis as damage argument per se doesn't work. So one doesn't get to the remoteness argument or the consequential loss because you haven't proved any damage.
Well, so the judge at first instance then erred in awarding any damages at all?
Well, no, my lord, with respect, because the reason he awarded damages was for a period of avoidable pain and suffering. And he referred to the...
Caused by?
Well, because he was in pain when he should have been in theatre. And when he was in theatre, he would have been anaesthetised and therefore monitored and managed.
But was the pain and suffering related to the bursting of the appendix and sepsis, or not?
No, it was related to the underlying condition of the appendicitis.
I see.
Because he was already in pain in the emergency department. That's clear from all the evidence. So, my lord, it's not consequential upon the sepsis, but it's, as it were, entirely conventional in these kinds of cases where there is a delay, you have an avoidable period of pain and suffering. So we don't complain about that. So we know that this is a threshold case, unlike Bonington. So the plaintiff needs to prove and establish the tipping point. It's no answer to that argument to say it's all risky and so you can infer a contribution to the outcome, because that is exactly the point we've just been discussing. And it's no answer to that to say that he can recover for the septic load. It's also no answer, with respect, we say, to say, well, you can just infer from the nature of the damage. May I take the board to volume 1, it's Barker, volume 1, tab 7, the judgment of... probably was judgment, actually, in Barker.
Barker?
Supreme House of Lords.
It was
opinion.
House of Lords, yes.
Yes.
I can remember where we discussed it.
Yes, well, so it's page 167, hard copy, 1074-5, electronic bundle. Paragraph 13. And at paragraph 13, Lord Hoffman says this: the House treated McGee as an application avant la lettre of the Fairchild exception. This came as a surprise to some commentators, see for example Tony Weir, making it more likely versus making it happen, because Lord Breach of Harwich, speaking for the House in Wiltshire, had said that McGee demonstrated no more than a, quote, robust and pragmatic, brackets, i.e. in the teeth of the evidence, close brackets.
I'm sure Mr. Brown wouldn't accept that when he said robust and pragmatic.
Inference from the primary facts. And then goes on to talk about only Lord Hutton being willing to accept this. And there are two further comments, both from Lord Hodger and from Lord Hoffman in Fairchild itself, about the limits of common sense. I do have those references somewhere, but not immediately to hand. Yes, it's volume 2. I don't take the board to them. Electronic copy, page 1398, paragraph 53, and page 1436, electronic paragraph 150. In terms of hard copy, rather more difficult because these are inserts. So it's volume 2, and it's tab 19, and paragraph 53.
I mean, the key thing is that once you've got the paragraph, if it's hard copy, once we know the paragraph number, the page number is academic.
Well, in that case, I won't take up time. Thank you very much, my lord. Which takes me, I hope, to facts insofar as I will address that extremely briefly, and then procedural impropriety of trying to make new findings at this level. And I'll deal with what I was going to deal with last. I'll deal with that first in terms of causation. There is in the appeal bundle, the main appeal bundle, red pages 571 to 2, black 478 to 479.
Sorry, could you give me the red number again?
Yes, 571 to 2, my lady.
571 to 2. Thank you. Sorry, I was reading Lord Hoffman on common sense, which I thought might provide some useful quotations.
Well, the most, one might also say, with respect, entertaining polemic, is the lecture to the Chancery Bar Association from Lord Hoffman, which deals with all the Alpha and Woodward references to common sense and so on, and the limits of it. And I'm sure that the board is familiar with that. It's certainly a good read. At page 571, right-hand column, underneath the two tables, I should identify the document. It is the Ingraham paper, Effective Delay on Operation on Outcomes in Adults with Acute Appendicitis.
So which volume is this? I'm so sorry.
It is the main trial appeal bundle where the grounds...
In bundle G, I think.
I'm not sure it's in bundle F, actually.
I'm so sorry, the board has got obviously...
What's the black page number?
478.
Yeah, that's bundle F.
I beg your pardon, I thought it was advice.
Thank you. I'm terribly sorry, I don't know.
It's all right.
Bundling. At least I have the pages.
Oh, well.
Yes.
The copying is shocking.
What do you want to draw our attention to?
478, right-hand column underneath the table, the following conclusion. Unadjusted overall morbidity rates were higher in the greater than 12-hour group, although there was not a statistically significant linear trend across the time intervals. That's an important point.
These are
These
the 32,000 patients, and we've no idea whether their appendices perforated.
Well, in fact, having gone to the inclusion criteria, they are all appendiceal cases.
Oh yes, they're all appendix cases.
Yes,
but what we don't know is whether any of them or how many of them are perforation cases.
My lord, we don't, but we do know that they're all appendiceal.
The delay, the consequence of delay, the impact of delay is likely to be hugely different after perforation compared with before, isn't it?
Well, it is, and of course that's one of the things that you can't measure. But what they do measure in the outcomes, it's at page 476, black.
Yeah.
Underneath outcomes, primary outcomes of interest were 30-day overall morbidity and 30-day serious morbidity or mortality. Overall morbidity was
Defined as having documentation of a serious morbidity, or at least one of the following, blah, blah, blah.
Yes, sorry, I need my other... Yes, defined as serious morbidity, at least the following, and then superficial rate of infection, deeper surgical site, etc. Serious morbidity and mortality was defined as having documentation of mortality of at least one or more of the following. Further, 3 lines down: cardiac arrest, myocardial infarction, bleeding, etc. Ventricular dependence of more than 48 hours, and so on. So this claimant would have come into the serious morbidity or mortality group, and on its face, this paper appears to suggest that in the surgery up to 12 hours group, there is no definable or discernible difference in morbidity or serious morbidity. That's what it appears to be showing. So, which takes us into the scientific yes. So it takes us into the scientific impossibility or difficulty. We need assistance to interpret this paper, but on its face, that is what it appears to show. It was only explored at trial with reference to standard of care, not causation. And that's part of the reason why I submit, as I will in a moment, it would be procedurally wholly irregular for a tertiary appeal court on the papers alone to try and make any kind of common sense, unquote, determination of causal relevance of a period of delay, let alone trying to recalibrate the period of delay on the basis of the papers. Because on the face of this evidence, it looks as though the plaintiff would not have been able to show any kind of doubling of the risk of serious morbidity between the period when the end of the innocent rupture, or the end of the innocent septic process, whenever that was, and the commencement of the guilty.
Do you want to say anything in response to Mr. Brown's reliance on the scan?
Well, my lord, yes, because so far as that point is concerned, the plaintiff's original argument was that the scan showed no evidence of perforation, and the perforation occurred after the scan. That was not the case that was ultimately accepted. The scan did show some free intraperitoneal fluid. It's clear from the mechanics of the operation, and this is Dr. Kahn's evidence, that what happens is the patient was put on the operating table, the abdomen was inflated with gas so that it created a reasonable operative field, the table was tipped up so the patient was on his head at a steep angle. That, of course, would have the effect of tipping any fluid that was intraperitoneal against the base of the diaphragm.
The scan showed fluid, did it?
Yes.
Because the bit maybe some other bit, but the bit we were taken to in the transcript was when Dr. Lightman was asked what the scan showed. Well, in the black copy, in the transcript bundle, it's page 120. That was the passage we were taken to.
Yes, thank you. Yes, I have that. And one of the things that he refers to there is free air, but he also refused, yes, they would also need to see evidence of free fluid. That's lines 24 to 25. And then goes on to say those three things would suggest perforation.
Those are the things which would suggest perforation, but he's saying that the CT scan was reported as not having perforation.
Well, it was reported as showing suspected inflamed appendix, so suspected appendicitis. But what Dr. Lightman appears to be saying is that you needed all, the three. Now, the scan actually showed one of them, and I probably need to go to the judgment for that.
Well, it may have been incorrectly put to the witness, but it was put to him at line 11 that the report said no rupture, and he says yes. And then he goes on to indicate the sort of things which would enable a diagnosis of rupture to be made.
Yes, it does, my lord, but the scan itself, and I'm sorry, hopefully we will find the page reference to the scan. The scan itself does report free intraperitoneal fluid. And that will be completely consistent with the judge's finding that the appendix had ruptured, or the rupture had started at around 19 hours. If my lord turns 2 pages on in the transcript to black 124, we have there being further on in chief, deal with, in my opinion, based on my experience, at the bottom of 123 onto 124, difficulty was caused by intra-abdominal gas pressure, etc., in the deep, steep head-down position in which he would have been faced. So he was asked about that. And if we go to page 128, Black, the top of that page, it just begins at the very bottom of the previous one, and Dr. Miller highlights the free fluid identified on the CAT scan in Mr. Williams's pelvis. And while the radiologist did not determine the nature of the pelvic fluid, and while there was no interpretation of a perforation, Dr. Miller made note of that fluid. And fluid is a sign of, answer, well, it can be pus or it can be some other fluid, but obviously Dr. Miller makes note of it. And I think moving forward, we get a better understanding of what that fluid was.
Dr. Miller was a radiologist, was he?
Yes, I believe he was, but I'll be corrected if I'm wrong. But the judge then said, so with the benefit of hindsight, it's evidence of a ruptured appendix. Yes, my lord. Yes, of course. Thank you. Counsel Miller was the surgeon. Thank you. Yes.
Right. Oh, yes. Thank you.
So the CAT scan, CT scan, did show free intraperitoneal fluid, consistent with everything else. Clinically, he was stable, but there was evidence of fluid.
Thank you.
But my lady, my lords, it takes me to I think 5 minutes. It takes me to two other points which relate to the facts. The first is that the judge had explicitly rejected the defendant's case on breach, and he had implicitly rejected the plaintiff's case on breach. Because the two contrasting cases, defendant's was 12 hours was fine, Dr. Lightman's was 2 to 4 hours, but 2 to 4 hours was challenged, and I gave the references to that yesterday. It was challenged on the basis of the papers and on the basis of Dr. Conn's, or Mr. Conn's evidence. But the point is it was challenged. And so what the judge then has to do is make a finding. What is the standard of care? And he made a finding of 5 to 6 hours. That wasn't, as my learned friend suggests, with respect, a speculative finding. It was a finding he was absolutely entitled to reach. Namely, I don't accept 12 hours. I don't accept 2 to 4 hours. 2 to 4 hours is expressly challenged in the transcript and the evidence by Dr. Conn, who said it was very aggressive. Well, the judge obviously thought it was aggressive too, and determined that the standard of care was 5 to 6 hours. That was something he was absolutely entitled to do. It was not mere speculation. So, having made that finding, a plaintiff on the basis of Belitho and Joyce can prove causation in one of two ways, in omission cases, either by showing that the defendant would in fact have done something that would have avoided the damage, or that they should have done something which would necessarily have avoided the damage. And that's up to the plaintiff, although in terms of obviously calling doctors as to what they wouldn't have done, is more normally within the defendant's regime. But the plaintiff has an alternative way of proving causation if they can't prove the factual one, and that is that they should have done something, and that's what they tried to do here. And that takes us to the chronology, which I will invite the board's attention to, but I won't address it in any detail. But in the chronology on appeal, as an annotated chronology, but I'll find the page reference in a moment. I thought I had it.
382 red. No, it's 382 red, 289 black, I think.
Thank you very much.
289 black.
Yes,
So I see, yes.
Yes, I'm very grateful. I have it at... Yes. Yes. Page 290 onwards. The point is, well, 2 points. One, that they appeared to accept the judge's finding that the CT scan was ordered at 1:10. So they didn't challenge Dr. Okereke's, as it were, acceptance of the point of, well, I did it within about an hour. They didn't challenge that. The rule in Ludden Marshall does not apply in Bermuda. So it would have been entirely open to the plaintiff to call evidence on appeal, either to deal with the causation point, a new argument as found by the judge, namely the operation at about 7:10 at the outside, would have been entirely open to them to deal with that, and they didn't, because they chose to deal with it by Bailey. They accept the 1:10 finding, and then at page 294, black, they give a whole range of different times at which, on different reconstructions, the surgery might have begun. So, with the greatest of respect, on this kind of evidence, if the board was to try and seek to reconstruct the facts, which were challenged before the trial judge, unlike in many of the other cases my friend referred to yesterday, in Wiltshire where the evidence was disputed, it had to go back for a retrial. In this case, the evidence was hotly disputed, both on breach and on causation, and even the plaintiff on appeal didn't state and identify a clear case for surgery based on evidence, and nor did they do what they could have done, which is adduce further evidence dealing with causation. So, my lord, it would be, in my respectful submission, wholly inappropriate for a tertiary appeal court, on the papers alone, to seek to make alternative findings. I completely accept that one needs to do justice to the claimant, to Mr. Williams, and I've already indicated that, so far as he is concerned, he's had his damages. We understand he's given them to charity, which is extremely noble of him, and I would like to say that publicly. The hospital has already indicated that we would not, under any circumstances, seek to enforce any kind of recoupment from him in respect of his damages. We simply wouldn't do that. Oh,
What would the
yes,
purpose be of a retrial in those circumstances?
well, one knows what the reality would be.
Precisely.
One knows what the reality would be.
Thank you.
But one shouldn't distort the process, the tertiary appeal process, nor should one distort
For that
the law
reason, yes.
For that reason. My learned junior has very helpfully given me a reference to the CT scan findings. It's black 427, red 520 from Dr. Miller's statement.
Sorry,
Dr. Con's report. Black 427.
Yep.
Red 520, and it's the bottom quarter of the page, and he quotes the CT scan, the radiologist's report.
Yep. Thank you.
And I probably don't need to say this, but in closing, if one looks simply at, this is the third bite of the cherry. He ran but for a trial and failed. He ran a different case on Bailey in the Court of Appeal. He failed. There can be no doubt that in the Court of Appeal, the argument was only based on Bailey. That's for two reasons. One, because the Notice of Appeal expressly says so, and that is at red 109, black 16, paragraph 3.8. And the relevant passage in the Court of Appeal judgment is red 158, Black 65, paragraph 36. So Bailey only was run in the Court of Appeal. And now here we are, for the first time in the respondent's written case, we get an attempt to re-argue but for on a different basis. It's in my respectful submission, wholly improper. I don't make any personal criticisms, but it's not right as it's procedure.
Happens all the time.
Well, the fact that it may do doesn't make it right.
No, we are very, very frequently faced with a different way of putting things from the way it has been put, particularly before the trial judge, who often doesn't recognise the case when it comes to us.
Yes.
The question as to whether we should be revisiting factual findings is a separate question from that.
Yes. Well, certainly it's that which, because of course the entire reconstruction depends upon new factual findings. And of course it's done in order to try and present a different causation picture. Would my lady forgive my back just for 2 seconds? I'm most grateful.
Could I just ask a question about costs,
Yes.
particularly in the light of what you have said about recoupment of the damages?
Yes.
Is your submission that costs should follow the event, or is your submission that this is an appropriate case in which to think about costs after the board has advised Her Majesty as to what the outcome should be?
May I take instructions on that point? I imagine that it may have been the first alternative, but I may be instructed to opt for the second. Yes, the first option.
Costs should follow the event.
Costs should follow, yes. Of course, a significant portion of the damages was the substantial bill subrogated insurance claim on behalf of Mr. Williams' private medical insurers. It was about $60,000 worth or so. That's a different matter, but that's an insurance company. But in terms of Mr. Williams personally, position is as I've indicated.
So how does that work on the cost front then?
I'm afraid to say I don't know the answer to that, my lord, so I'm not going to speculate. But I see the concern. I do see the concern.
Well, this is the sort of case in which, had it been a question of permission to appeal to the Supreme Court,
Yes.
because of the
Yes.
general public importance
Yes.
to which the NHS, had it been the NHS, would address, it's the sort of case in which we might have made it a condition of giving permission to appeal that you bore the costs in any event.
Yes, I completely understand that, and there may be an argument, and indeed I may receive instructions for part of it, but in respect of either the trial process or the appeal process in Bermuda, it would be, in my respectful submission, not right that there should have been a second bite on a completely different basis, but still without identifying it clearly. But
Well, I think to call it a second bite when you're the person doing the biting now is possibly a little bit unfair.
well, my lady,
They have to come to this board in order to defend the judgment that they got in the Court of Appeal. And if they can think of a better reason, well, then that's what they often do.
Yes, well, I accept that.
Calling it a second bite is a bit harsh.
I'm told my instructions are that in fact each party should bear their own costs.
Well, if there's anything further that anybody wants
Yes.
to say,
Is that in this court or across the board?
Will you forgive my back again, please, for a moment?
So we know what your position actually is.
Seems to be an ever-shifting...
Don't do it in too much of a hurry.
yes, exactly, that's what I'm thinking.
Yes.
Mr. Brown will obviously have words as well
Yes.
to say. I think this may be a case for submissions after the board has decided what the outcome should be. then mature consideration can be given to what would be the right. But I'll hear what Mr. Brown has to say.
As your ladyship rightly apprehends, I would certainly wish to be heard on costs.
Yes, of
This is
course.
probably not the appropriate time to make any submissions.
Well, given that you've got a shifting
Precisely.
target, and I feel sorry for Miss Harrison, who is obviously taking instructions on the hoof. So
Those instructions seem to have changed 3 times in the last 20 minutes.
Well, as the board will have observed, we're in the same chamber, so I've no doubt we can discuss matters between ourselves, so, in the hope that some compromise can be arrived at.
And of course, everybody will completely understand that you operate as completely independent practitioners.
Of course.
A set of chambers is not to be compared with a solicitor's firm, and so there's no question of that being in the slightest bit professionally.
Emily, that of course is right. On the other hand, it does produce, at least at the outset, friendly relations.
Not always.
We have known of exceptions. Yes, this is true.
In most cases.
Yes. So, well, that completes your submission, sir.
It does, my lady, and we absolutely hear the board's concerns about costs and
You'll go away and
respect.
think about it.
I totally respect
Yes,
that.
yes.
This is about trying to clarify a very difficult area.
Yes. And Mr. Williams, who's been patiently listening
Yes.
throughout to the arguments, which must have seemed
Yes.
mysterious, to say the least, because they
Yes.
sometimes seem mysterious to us too. And he will be relieved to know that in one sense at least, the outcome remains the same for him,
Yes.
even though there is a public interest in trying to
I'm most
clarify the
grateful,
law.
my lady.
Yes. We're grateful to everybody for the assistance that they have given us, and we will, of course, take time to consider what advice we will humbly tender to Her Majesty.
Bye.
We're now adjourned.